You are listening to the Gemini Legal Podcast. We're focused on California workers' compensation industry and the faithful practitioners. We are live. We have a special program at the California Applicants Attorneys Association Winter Convention in beautiful Rancho Mirage. I am Dan Mora. I am not an attorney, but I am the founder and CEO of Gemini Legal. We're a legal discovery company in California workers' compensation. My guest today, special guest, Scott Rubel. Scott Rubel is a practicing attorney. I don't know how many years, but you're in the Inland Empire, right?
I am. My office is primarily in San Bernardino. We also have an office up in Victorville. It's just a satellite office where we see clients and help people out up there. But primarily the Inland Empire, so we appear at the San Bernardino board, the Riverside board, and the Pomona board primarily.
Gotcha. So how did you get started in comp? What's your story? What's your background?
Oh my gosh. It's 1990. I'm working at a defense firm doing insurance defense, doing construction defect defense, med mal defense, and the boss comes into my office one day and doesn't like the way I'm doing things because I'm not billing enough. I'm settling cases instead of billing the crap out of them, and you should excuse the expression. And so I explained to him that I thought I was doing a good thing for his client, and he said it was my way or the highway, and I took the highway and walked out of that job with no place to go. And a small firm in Palm Springs, right down the street here from where we are at the convention, Gilbert & Burke, was looking for an associate attorney, and they took me in and they taught me PI and they taught me comp, and I've been doing that ever since. Then I went to Rose, Klein & Marius for about 8 years doing just workers' comp, and then Larry Lerner, former president of the California Applicants Attorneys Association, his office had a partner that was retiring and asked me to step into that spot, and that's where I've been ever since.
Amazing. And I feel as though you have to have a little bit of fire in your belly to practice workers' compensation. And these folks are if you've never had a work injury, if you've never had a family that had a work injury, it's hard to appreciate until you see it firsthand. But I think that most people kind of have to have that passion here in this industry. Is that true for you?
I completely agree with your statement. There are a lot of people in this business that don't have that they treat it simply like a business and a way to make money. And if you're doing that, you're doing a disservice to the clients. We hired a new associate in our office recently, Andrea Aguilar, and I remember talking to her at her interview, and I remember that the thing that caused me to hire her, other than her qualifications, which are impeccable, was that little glint in her eye when she would talk about cases and she would talk about successes. And you really need to have that. You need to enjoy doing a great job for people and getting them what they need or as best as you can. Because if you don't have that passion, that fire in your belly that you describe, you're going to be able to help people a little bit. You're going to get some benefits for them. You're going to get cases settled, and you're going to make a living. But you're not really doing everything that the system provides for them. So I agree with that. It's an important aspect.
And sometimes it takes one story to light that fire. Is there one story for you, one injured worker that was like, oh, okay, now I get it. This is the system that needs me badly, and I'm going to absolutely put my shoulder into this and do my best to serve this industry?
I don't really have a single case like that comes to mind. I've had all kinds of clients over the years that I've just been just very pleased to try to help. Honestly, it's been this organization that has kept that fire in my belly and that encouraged me to have that attitude when you're representing an injured worker. I mean, the people that have been part of this organization, I've been on the board of directors, I believe, since 1994. Started out as a chapter president, and I didn't have any clue what I was getting into. All I knew was that our local chapter president had had some issue and could no longer serve as the chapter president. So the Larry Lerner and Rob Vines approached me and asked me to be the chapter president in this chapter, the Desert chapter, which is no more. It's not here anymore. But at that time, they needed a chapter president. And so I showed up at one of our annual retreats called, at that time we called it long-range planning. Now we call it strategic planning. And I sat in a room and I listened to some of the most extraordinary lawyers talk about how they practice law and what are we going to do to help injured workers. I don't think the word fee came up during the entire weekend. We're there for 4 days. And nobody talked about fees. All they talked about was injured workers need this, injured workers need that. We need to do this from the legislature, et cetera. We need to do what we need to do to help these people. And I was instantly inspired by that.
Gotcha.
So that's really what got me going.
Yeah.
And I've been on the board of directors ever since, and as long as some president will have me, I will continue to be on the board of directors.
That's fantastic. That's fantastic. That inspiration is I see it that you're trying to pass that on to the next generation. And that's a question. You just hired somebody, and it's a question I'm having for that I have in general for businesses. You're a business owner. How is recruiting changing? How do you attract the best lawyers now, the youngest and brightest?
That's a really great question. I mean, it was a matter of just getting the word out, and Andrea was actually referred to us by a hearing rep that I know that just happens to be a friend of the family, and so she was just referred to us. But recruiting people to workers' comp, nobody goes to law school dreaming of becoming a workers' comp attorney unless you happen to be a family member of a workers' comp attorney. So people like Josh Friedman and Jeffrey Stern, I mean, those guys probably knew going in that they were probably going to join their father's practices. Mm-hmm. But I mean, there isn't even in law school, I don't recall there ever even being a class on workers' compensation. So attracting quality people to our practice is very difficult. Mm-hmm. But you know, fortunately, I mean, we have a lot of good people, a lot of good young people coming in to workers' comp. Andrea is one of them. I don't know if you know Megan Rubel, no relation. I often tease that I will not let anybody think that I am a part of her gene pool. I wouldn't want to do that to her reputation. But Megan Rubel is extraordinary, just became a partner at the Rockwell firm. She's the moderator for the most important cases, which is the most important panel of the convention. So there's a lot of good, bright people that are young people that are coming along. A lot of women, a lot of minorities, which we love. We're very excited to see that our board of directors and our practice is expanding into away from old white dudes like me. I mean, that's what this practice was for so many years, so many decades, especially old white Jewish dudes like me. I mean, you look around the state and that there's just a lot of us, and that needs to change. And so that's one of the things that our organization is doing, is trying to make those changes.
Gotcha. So what topics are you following nowadays, or what single topic is taking most of your attention at this point?
Well, the single topic that takes most of our attention in any case is medical treatment. And I'm assuming that if you ask that question of any applicants, attorneys here, any one of them that doesn't talk about medical treatment as part of the biggest problem in workers' comp is not paying attention. So, I mean, there's lots of issues and lots of problems, and there's no question that there's other things to talk about. Mm-hmm. But, you know, my clients, all they want to do is get better and get back to work. And if they can't get decent medical care, then that's just not going to happen. Statistically, I believe if a person is out of work for more than 6 months, there's a 50% chance that they won't come back to work. If they're out of work for a year, there's a 75% chance they won't come back to work. And if they're out for 2 years, it's almost infinitesimal the number of people that are actually going to get back to the job.
That's surprising. I mean, that's just a compelling statistic that for the speed and quality of care.
It needs to be provided, and needs to be provided quickly, and it's not. This whole concept of the UR-IMR method of evaluating doctors' opinions is not a method to provide speedy access to treatment. It's a method to provide speedy denial of treatment. And that's really what the goal of these entities seems to be. The insurance companies love to spout out a statistic, and I wish I brought the little document with me that had these statistics on it. But the insurance company likes to spout this statistic about how they're authorizing 93% of medical treatment. Well, there's two ways to look at that. One way is to say that means that statistic includes everything. That includes somebody gets a cut on their finger at work and they get a Band-Aid.
Yeah.
That's included in that statistic. But if you take those numbers and you change them to and you limit out all of those little first aid things that are just simple. If somebody falls and they hit their head and somebody calls an ambulance, that's first aid until they actually get to the hospital and we know more about what they're dealing with. Then that's the issue that is the problem. But then you look at it from a different point of view. 93% seems like a really good figure. But if you look around our state, one of the hugest problems that's affecting our state is homelessness. Everybody's talking about homelessness. Well, guess what? 99% of people who live in California are not homeless.
Right.
So all of a sudden, 93% doesn't sound like a really great statistic.
That's a great perspective.
There are other issues that you can compare that to. The bottom line is that every single day I've got extremely quality doctors that are well respected, what we refer to as AME quality doctors, treating my clients saying they need this treatment. And I've got doctors that couldn't hold a candle to them in a teaching hospital saying, nah, he really doesn't need that. The reality is that these doctors that are doing these evaluations, these utilization review doctors, they're not really making a determination as to whether or not the patient needs the treatment. What they're doing is evaluating how the doctor wrote the report. So when this whole system was created, this new system, the defense, the argument for this was, we don't want judges making decisions about medical treatment. We want doctors making decisions about medical treatment. Well, the problem is they're not making decisions about medical treatment. They're doing the same thing that judges did, in my opinion, much better. They're evaluating reports, and they're making a determination as to whether or not that report justifies the treatment. Under the old system, when somebody needed medical treatment, if a utilization review doctor said, nah, I don't think he really needs that, that created a dispute. How was that dispute resolved? We went to an AME or a QME. The AME or the QME examined the patient. UR does not do that. They reviewed all the records. UR does not do that. And then they made a determination. They ordered diagnostic testing if they felt it was necessary, and then made a determination as to whether or not that treatment should be authorized. And if anybody had a disagreement after that, then that report, along with all the other reports, the treating doctor and the UR report, that all went to a judge, and a judge reviewed all those reports and decided which was the most well-reasoned opinion. And that's the opinion that carried the day. I never saw any problem with that. Perhaps the only problem with that was because the defendant's UR doctor never examined the patient and didn't review all the records and really didn't know that much about the case. Perhaps they were losing too often and having to pay for too much medical treatment. So UR is not a method of providing speedy care. It's a method of providing speedy denials.
Yeah.
And that needs to change. It's a huge problem. I have clients that they need surgeries, they need therapy, they need injections, they need medication. And some doctor sitting in an office that's never seen them, never clapped eyes on them, never touched them, is saying, you don't need that treatment. And there's just, if that doctor was actually a treating doctor and was in the medical system actually trying to treat patients in that way, they would be committing malpractice every single day, because that by itself would constitute malpractice. Since they're not an actual treating doctor, there's no physician-patient relationship, so it doesn't technically qualify as malpractice, but it is.
Wow.
And it would be if that was the way that doctor was actually practicing medicine.
Wow. MPNs. I'm hearing people say get rid of it. I'm hearing also ideas about a state MPN. What's your thoughts? And how you have a magic wand, and what could you do? What would you do? You talk about UR. So it seems like people either gravitate towards UR or they gravitate towards MPN.
Those are, the MPN is an ongoing problem for so many reasons. 90% of the doctors, I think, that are in MPNs, I know that, I'm making up that statistic, but it seems like so many doctors that are in the MPNs, they either don't know they're in an MPN or they're not willing to take patients out of the MPNs. Many doctors have refused to take patients if the injury is more than 2 years old. So if we look at an MPN and we see 20 doctors that are in my client's geographic area, and 19 of those doctors aren't taking patients that are because the injury is more than 2 years old or more than a year old, or there's already been a surgery on the case or whatever, then that MPN is not doing much good for that particular patient. How to solve that problem? We used to have free choice of treating doctor, and it worked. For a while there, the insurance companies made the treating doctor presumed correct, which I think was a huge mistake on their part. And then when they changed that law, they took that law out. Before that could take effect, before we could see what was going to happen with that, all of a sudden we're changing the law again, using statistics from before the change to support another change to the MPNs. There are some MPNs that have plenty of good doctors in them, and then there are others that are really, really, really a problem. And what is the solution? I would love to go back to the free choice of treating doctor. I think a patient should be able to choose their doctor.
Sounds logical.
But I do understand that can be an issue for the insurance companies, and they want some say in who the doctors are. And the idea of a statewide MPN would be great, but I don't know how workable that is. If it's the state making the decision, then it would seem like any doctor should be able to say, I'm a medical doctor, I want to be in the MPN, and they would have to provide that because the state can't discriminate. So, but the MPNs as they are now, they can be very sanitized, and it can be a problem. Some are arguing that if the doctor is in the MPN, well, that's their doctor. So why are you sending your doctor's opinion to utilization review? Why shouldn't you just abide by the doctor that you have forced us to send our patient, the patient to? And I think that's a legitimate argument. So if we could get rid of UR for MPN doctors, that might solve a lot of problems.
I have this theory, and tell me if I'm wrong, but MPNs were created as a response to the lien problem system, problem that we had in the system.
MPNs were created for a lot of reasons, and that's certainly one of them. They didn't like doctors treating on a lien, but the lien issue was solved in a very different way. The lien issue was solved by making doctors pay a filing fee. It was solved by putting a lot of onus on the doctor to get paid on a lien. And so a lot of doctors just withdrew from the system and have stopped treating. To find a doctor that will treat a case on a lien is nearly impossible in my area of practice. There are precious few of them, and often we only avail ourselves of that in denied cases. But that's certainly one of the issues that the MPNs were created for. But ultimately, I believe the MPNs were an effort to fix their failure to create HCOs. If you remember, in the middle there was this concept of the healthcare organization, HCOs. And when they created the presumption of correctness of the treating doctor, they created that at the same time as they created HCOs. And if a carrier or an employer could create an HCO, the HCO would have medical control for 365 days, and they would have the presumption of correctness. The problem that they had was that the way the regs came out and the statute came out as to how to create an HCO, they weren't able to do it. So now if there's no HCO, we have free choice of treating doctor and the presumption of correctness, and that was causing them a tremendous amount of problems. I never thought the presumption of correctness made any sense at all. I mean, I'm going to use it to my client's advantage if I can, because that's the law. But it never made any sense that a treating doctor should be presumed correct. The only person that should be presumed correct in our system is an agreed medical examiner. And that's even still rebuttable to some extent. Now we've gone to this bizarre situation where the independent medical reviewer, this anonymous doctor, we don't even know who he or she is. We don't know anything about his or her qualifications. We don't know anything about his or her background. We don't know anything about his or her bias. I mean, it says right in the report there that they're not biased, so therefore it must be true. We don't have any information about this doctor, and that's the doctor in our system that is presumed correct now. That makes no sense at all.
It's completely additional layer of scrutiny that seems to not be working.
Well, it's definitely not working. I mean, they're paid a very small amount of money, as we understand it. The company they work through, Maximus, and there should be like an echo on your mic every time I say that word. Maximus. Yeah, exactly. That company gets a certain amount of money, but the doctor that's actually doing that work gets a small percentage of that. They get a few records that they're supposed to review. I know that we've sent them records on cases, the IMR doctor, we've sent them records that the defendants didn't send. They listed the record in the report saying that they reviewed it, and then said something that was completely inconsistent with this record that they supposedly reviewed. And we have no recourse to that. I can't set that doctor's deposition and ask him or her questions about what they reviewed and how they reviewed it and how did they arrive at their decision, because I don't know who that doctor is. And there's no way to find that out. And that's the doctor that's presumed correct. That's the doctor that is making the final decision in workers' comp cases. Yes, we can appeal it. There is an appeal process. We go to a judge. We tell the judge, hey, they said this, it's inconsistent with that. And the judge says, oh, okay, well, here's the real fact. Now send it back to the doctor and let him decide it again, because the judge has no jurisdiction to reverse the IMR doctor. All he or she can do is note the correction that needs to be made and then send it back and hope that the IMR doctor will consider that. Almost never happens.
Sounds hopeless. So where's the hope?
Well, unfortunately for society at large, the hope is outside of workers' compensation at this time. So the constitutional amendment that deals with workers' comp basically says that it's the employers that are supposed to be dealing with problems of a work injury, but it's being shifted outside of workers' comp. So Medi-Cal, health insurance, Medicare, they're the ones that are bearing the burden. State disability, private disability policies, these are the people, these are the entities that are paying the cost on these cases that should not be paying for it. So my client, has a denied case, or my client needs a surgery, and the insurance company, the UR doctor says absolutely not, he doesn't need that. He goes to his health insurance and he gets it that way.
Right.
And they're not supposed to be paying for medical treatment that relates to a workers' comp case.
Right.
So that's where the solution is now.
Yeah.
The solution in the long term, we've got to, in my opinion, go back to the system where utilization review is fine. I have no problem with a doctor. I'd much rather a doctor rather than an insurance adjuster who maybe has a high school diploma, and they're very bright people, some of them are very experienced, but they're not qualified to make medical decisions. And I agree with having them have a doctor identify cases where there is a question as to whether or not medical treatment should be provided or not. But we should go back to the system where that simply created the dispute, which was then evaluated fully by a doctor that was either a QME or an AME, reviewed all the records, examined the patient, did the diagnostic testing that was necessary, and made an informed and substantial evidence decision on whether or not that medical treatment really needed to be provided.
Gotcha.
That's the system, and as far as I could tell, that system was working. People were getting care, people were getting better, we were getting reasonable resolutions of cases, and we were getting people through the system.
I asked a similar question to somebody else, and I said, "Where's the hope?" And the answer was I thought was good. It was we find a way. We find a way to get these folks the treatment, the care that they need. What's your thoughts on that?
Well, yeah, I find a way.
Yeah.
But you have to understand that 75% of the people that are in this system are unrepresented.
Yeah.
They don't have me helping them through it. They don't have me holding the insurance companies to task. They don't have me cross-examining treating doctors and getting them to say the things that need to be said so that we can get them get the patient the treatment. They don't have nurse case managers that are, in many of those cases, that are working for the injured worker and communicating with the treating doctor saying, okay, if you want to do this treatment, that's fine, but in order to justify that treatment, you have to make sure that your report says X, Y, and Z.
Right.
Because that's what the medical treatment utilization schedule requires. They don't, they don't have that kind of assistance.
Right.
Yeah, I help my clients get a lot of medical treatment that other people are not getting. But there's a lot of people in this system that are unrepresented. And they don't have that kind of assistance. They don't have that help.
Right. Softball final question. What's your team? Who's your team?
In the Super Bowl?
Well, let's talk. It was in the Super Bowl.
Well, that's a tough one because I like them both equally. I'm not trying to be I'm not trying to be difficult or weenie, if I can use that word. I love the fact that the 49ers beat the Packers because I am a Chicago Bears fan, and the Packers, I would not be able to stomach the Packers in the Super Bowl.
Luckily, it was quite a beating.
It was a shellacking. It was great, and I was very happy to see that. So I have a warm spot in my heart for the 49ers. But I think Patrick Mahomes is amazing, and I would love to see him win a Super Bowl too. That guy is extraordinary. I roll over in bed constantly, realizing that the Bears could have had Patrick Mahomes in that draft. We chose our quarterback, Trubisky, 2nd overall, and Mahomes went 10th overall in that draft. And there's not a day goes by that I don't just shake my head and think, what the heck were they thinking? I mean, Trubisky's okay, but Mahomes is extraordinary, and I really would like to see that guy get a Super Bowl. I think that's awesome.
Yeah, that'd be great. Well, thanks, Scott. You're an advocate for injured workers. You're an advocate for us, the associate members for CAW. Thank you for what you do. Thank you for your heart for injured workers, and thanks for being on this show.
It's been my pleasure. Thanks for inviting me.
Absolutely, my pleasure.